Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. That's right, we're on the road today. The sheriff was able to let me use a little room here to do today's show, so let's get to the docket. First, Alec Baldwin news. The gun did not just go off. Lori Vallow and Chad Daybell news as well. And then Amber Heard. She brings in big guns for the appeal. A family that does time together stays together. And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. That's right. It is Scott Reich here, and we are on the road today. We are not in studio. Had to take care of some of that lawyer stuff. And we are, in fact, in Delta, Colorado. The sheriff up front, who seems like I've spent a lot of time with him today, was gracious enough to let me borrow a room that was not occupied so that we could do this video for you today. So before we get to the docket, you know the drill. Subscribe if you haven't, like if you do, hit that bell for notifications, and remember you can listen to us on our podcast anytime by listening to us on any of your favorite podcasting apps. Let's get to the docket for August 15th, 2022. All right, first, an FBI forensic report has concluded that the gun used in the fatal shooting on the Rust movie set last year could not have been fired without pulling the trigger. Now remember, actor Alec Baldwin fired the shot that killed cinematographer Helena Hutchins during rehearsals for the Western, as previously reported. Now, Baldwin believed the gun he was handed was cold, meaning it didn't have live ammunition in the chamber. Well, Baldwin also, the producer of the film, previously said he didn't believe he had pulled the trigger and that the gun went off while it was in his hand, striking Hutchinson in the chest and wounding director Joel Souza. Now, a copy of the FBI report has been obtained, and agents determined that the .45 Colt could not be made to fire without a pull of the trigger from the quarter, half, or full cocked position. The gun could detonate a primer without a pull of the trigger when the hammer was struck directly from a de-cocked position. The Santa Fe County Sheriff's Office, which is leading the investigation into the shooting, said it received the report and other FBI documents earlier this month. Those documents were reviewed by the New Mexico Office of the Medical Investigator, which classified Hutchins' death as an accident. Well, death was caused by a gunshot wound of the chest. Review of available law enforcement reports show no compelling demonstration that the firearm was intentionally loaded with live ammunition on the set, the post-mortem report stated. Based on all available information, including the absence of obvious intent to cause harm or death, the manner of death is best classified as an accident. Now, we did a video about this months ago. As you may recall, I brought in my antique firearm and I explained to you how this revolver could not just go off. Everybody knew that. Those revolvers are not like a lot of the new firearms these days, which have the potential of going off because it's a wholly new mechanism. The next question is, well, don't we make accidents criminal? Well, we do. I have a real problem with that because negligence is a foreseeability issue and it's a reasonable man standard. And the reasonable man standard, frankly, has no place in the criminal justice system. The United States Supreme Court justices are coming around to this notion because in the criminal world, it's a knowing. They have to establish a mens rea, whereas with a negligence charge, it's, well, what would a reasonable person do? Well, if a reasonable person would do it, well, go sue them in civil court. It's a much lower burden of proof. And frankly, I think it lowers the government's burden of actually showing that one intended to commit a crime. So have a real problem with negligence. The prosecutors in this case could, in fact, do some sort of criminally negligent homicide, maybe a reckless homicide, saying what a reasonable person would have done was to check the rounds, even if the person that gave it to you said that there were no live rounds in it. What would a reasonable person do? Rely upon it or check it themselves, or just let them go fight over the money. Let me know in the comments what you think needs to take place, but go check out that video as well where I explain the functioning of that antique firearm. Next on the docket, let's talk about Lori Vallow and Chad Daybell. Guess what? The state has filed their objection to the defendant's motion to remand to the grand jury for probable cause determination. As you may recall, the defense wanted aggravating factors to be placed into the elemental instruction, and they cited some case law for it. Now the prosecution has finally filed their response. It's dated August 12th, and they basically say there's no constitutional requirement that the state present evidence demonstrating probable cause for each aggravating circumstances to properly notify the defendants of its intent to seek the death penalty. Now, the issue has to do with the case out of Arizona that said an aggravating factor that increases a punishment has to be charged, presented to a jury, and proven beyond a reasonable doubt. The next argument that the prosecution said was, hey, it's untimely. You should have filed this sooner. But they do concede the fact that, well, defense counsel recently just got on the case, and there was this whole situation of competency. So, Judge, we think you can probably hear the issue in that regard. You have the discretion to do so. So we'll discuss this more tomorrow night when we go live at 6 p.m. Mountain Time on our Tuesday night live show on both YouTube and Facebook. And what is the significance of the argument that the defense and the prosecution are arguing about? This Arizona v. Ring case was a Supreme Court case that said if you are going to have all these aggravators, you have to prove it because it increases the punishment. And therefore, our founding fathers would have said, you got to charge it, present it to the jury, and prove it beyond a reasonable doubt. Okay? For years, states were saying, let's just charge this person with the death penalty, and we'll just have a three-judge panel decide what to do. Of course, as you can't do that. It's got to be presented to the jury. So the defense is really saying, hey, we're unsure what you're doing here in these charging documents, but we think you need to take it back. Now, Idaho apparently has ruled on the case. I will read that case by tomorrow and be able to explain it further if it's really necessary. But the issue then becomes, do you want to create an appellate issue, or do you just go back and say, fine, we'll do whatever you want, and we're still going to convict your client? That's what I think a good prosecutor should do, but we'll talk about it more tomorrow night when I get back from this little road trip. Next, there was a stipulation in the matters regarding the DNA testing of the defendants. So Chad Daybell and Lori Vallow have come to a stipulation where their respective counsels agree and follow regarding the consumptive testing. 1, the parties agree that the samples listed in the state's motion for the consumptive testing may be consumed by the state lab, and they're going to determine if there's a sufficient representative sample. And in the event a sufficient DNA sample is in fact available to create a more than one profile, the DNA sample will be split between the parties for testing, and each party may have the expert of their choice test the respective portions of the DNA. In the event sufficient DNA is available for one profile to be created, the parties agree the state lab shall halt further testing if there isn't enough sample there, and then they will determine at a later time who should conduct any further testing. And fourth, in the event the state lab determines there is not a sufficient DNA sample to create a DNA profile, the parties shall reconvene to determine what, if any, course of action to take. Now, what does that really boil down to? As you may recall, we talked about this. Normally, it's the government's evidence. They can test it when they want. If it's going to be consumed in testing, they have to tell the court. The court says, defense, go coordinate with them. You can watch, you can observe, but it's got to be done. It's unclear why the defense, or the prosecution in this case, is agreeing with the defense and basically doing anything. The state should test it. If there is enough for the defense to sample their own sample, fine, that's great, they get to do it. If there isn't, then the other party should be present and they can test it and they can do what they want. But now this last thing is if they can't agree and there's not enough sample, then they're going to reconvene and decide who does the testing. You know what that spells? One word, ladies and gentlemen, DELAY, delay. If anyone hasn't noticed, we're almost on September, right? September, October, November, December, 4 months until we start a trial. And they're still trying to figure out when the DNA testing is going to be done. Are you kidding me? Get this show on the road. This case is the prosecution's case to lose. And if they want to sit around and play games like this motion should have been filed months and months ago, in my humble opinion.
Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado, CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked.
Next on the docket, Amber Heard. She is out with the old and in with the new when it comes to her legal representation. Now, she's scrapping a key attorney on her team and bringing in the big guns. The actress who is currently appealing the Johnny Depp verdict announced Monday that she's hired the law firm of Ballard Spahr, big one, expensive, as she ventures into the appellate court, which she apparently thought warranted a fresh set of eyes to review the case as well as the evidence thus far. The lead attorneys from the firm that are coming on, David Axelrod, not the Obama CNN guy, and Jay Ward Brown, both of whom successfully defended the case for the New York Times against the defamation suit recently brought by Sarah Palin, a First Amendment case, their specialty. Now, Amber is keeping Ben Rottenborn on board with the addition of Axelrod and Brown. She's losing one lawyer, Miss Elaine Bredenhoft, who was lead counsel in the trial. Her departure from the team isn't really explained beyond simply saying she's stepping down. Now, as for the new boys on the team, we welcome the opportunity to represent Ms. Heard in this appeal in a case that is important in regards to First Amendment implications for every American. And they added that they're confident that the appellate court will interpret the law in their favor and clear Amber Heard's name, according to their attorney. A rep for Amber Heard says when it comes to protecting fundamental rights of freedom of speech, we look at the jury's decision to paraphrase a famous quote, not as the beginning of the end, but merely the end of the beginning. A different court warrants different representation, particularly as so much new evidence is now coming to light. Well, that's kind of ridiculous in a certain regard. One, I certainly encourage somebody that loses at the district court level to get new counsel to look at the record on appeal to see if some errors were in fact made. You kind of get tunnel vision. I don't do appeals that I did the trial on because, frankly, that's not my specialty. I could do it, but it's just simply something I don't have the time for as a trial attorney. So Amber Heard's making a good decision on that part. Now, we will see if Scott Wright is ultimately correct when it comes to this issue, because Johnny Depp's a public figure, a matter of concern. So I'll be very surprised. I think the district court may have got it wrong. Just saying. Took a lot of heat for that, but we will see who is right. Now, the statement about new information coming to light, not relevant. The record on appeal has been made, unless, of course, the court's earlier ruling resulted in some unfair basis that resulted in an unfair trial for Ms. Heard. We'll see if the court did it right or if they got it wrong. But that's what appellate courts are for. We'll obviously follow the case of Ms. Heard in the future. Next on the docket, The son of a man who has been arrested as the prime suspect in the serial killings of 4 Muslim men in Albuquerque, New Mexico, may have helped his father carrying out some of the murders. Shaheen Saeed, he's 21, came under scrutiny from the police after his father, Muhammad Atif Saeed, was charged with the murder of Aftab Hussein on July 26 and Muhammad Afzal Hussein on August 1st. Now, police have said the 2 guns and bullet casings matched those found at the scene of both killings to those found in Muhammad Saeed's car and home. Federal authorities now say they believe Shaheen Saeed is a primary suspect in the November 2020 death of Naeem Hussein. Now, Shaheen Saeed is currently in custody on a separate charge after he allegedly gave a false address that claimed he was a Florida resident in order to purchase a gun in June of 2021. The authorities are now looking further into what role the pair may have played together, with cell phone records indicating Shaheen may have possibly helped his father spy on Naeem Hussein before he was shot on August 5th outside a refugee service center in Albuquerque. A statement by the police said that we always believed that it would be hard for one person to do those murders. That's a spokesperson from the Islamic Center of New Mexico when he was told of the son's possible involvement. He stated, quote, "I believe the community is out of fear now. They believe that whomever's responsible, they're behind bars." We'll continue to follow this case. It's a classic case of a family that does time together, stays together. Finally, our dumb criminal of the day. A Georgia man is behind bars after calling police about cold French fries. That's right. Video shows the police were called to a McDonald's about a customer complaining about cold French fries. Now, after talking with all of the parties involved, the police discovered that Antone Sims, the man complaining about his cold French fries, well, they figured out he had a warrant for murder. Mr. Sims immediately took off running. Police were able to catch up with him in an apartment. He received the taser treatment, often part of the harassment package, prior to arrest. Now, Mr. Sims was wanted for the death of a woman found in a burning car in Lawrenceville, Georgia, back in 2018. Now, you must love how food brings people together. At least no one was injured in this particular case when it comes to food. We brought people together. Food is bringing people to justice. All right. Thanks for being patient with me on the road today. Thanks for watching. We'll see you next time on Crime Talk. And don't forget our live show tomorrow, 6 p.m. Mountain Time. Have a wonderful day. We'll see you next time.